Hi, George.
Hello.
Hello. Hello. Boa tarde. Nós, então, vamos dar sequência ao nosso seminário, né? E, nessa sequência, nós vamos ter a palestra do professor Jorge Bisharat, né, da Universidade da Califórnia, da Faculdade de Direito da Universidade da Califórnia em São Francisco. E teremos aqui, depois, as considerações e as observações e comentários da nossa colega, né, doutora Paula Campos Pimenta Velloso, que é professora do Direito lá da Faculdade de Direito da Universidade Federal de Santa Catarina e pós-doc, né, da UVA. Não, é da UVA? É, da UVA. É porque eu tenho professor de pós-doc distribuídos e tal, então eu nunca sei direito. Sei que eles são pós-docs, eu sei que eu sou o supervisor, agora da onde? Aí já tá, tem que perguntar, né? O título da palestra do professor Jorge Bisharat é Palestina na Corte, no Tribunal, né, na Corte Internacional de Justiça. Aí tem um truque, né, no título dele, porque ele diz Law versus the Rules-Based Order. Quer dizer, o direito contra a ordem fundamentada, né, ou baseada em regras, né, entre aspas. Então, isso ele vai certamente nos explicar isso quando fizer começar a sua palestra. Então, George, my friend, there you are again. Thank you very much for being with us again. And I already introduced your talk and your conference and the title. Mm-hmm. And I already told you, but I am introducing you also to Dr. Paula Campos Pimenta Velloso, who is going to comment on your talk.
Wonderful.
Thank you very much. And,
Thank you.
I'm really listening.
Okay. It is always a privilege and an honor and a pleasure to be with all of you. I'm deeply grateful for the invitation to speak to you today. I'm going to be speaking to you about 3 cases related to Palestine that have been before the International Court of Justice in The Hague in the last year. The first is South Africa versus Israel, in which the former is charging the latter with violations of the UN Convention on the Prevention and Punishment of the Crime of Genocide of 1948. This case was filed in late December of 2023. There have been several interim rulings that have been made by the court that are worth discussing, but otherwise the case is continuing and a judgment will not be reached for years. The second is the case filed March 1st of this year, in which Nicaragua is charging Germany with complicity in the Gaza genocide. Likewise, the court has issued an interim ruling, which I will briefly describe. And then the third case is the United Nations General Assembly's request to the International Court of Justice for an advisory opinion arising from Israel's continuing military occupation of the West Bank and Gaza Strip and denial of the Palestinian people's right of self-determination therein. Now, this case was actually initiated before the other 2 cases by a vote of the General Assembly in 2022. But the court's judgment in the matter was just issued July 19th of this year. So we can actually, we're actually in a position to examine and not just speculate about the outcome of the case. Together, these cases, in my view, constitute a litmus test regarding the direction of the global community and the direction it may take in the years ahead. On the one hand, will it support the primacy and universality of international law?
Não, eu mandei um zap para ele, né? Quer dizer que ele desapareceu.
Achando que tá tudo certo, né? Ele vai seguir lendo lá.
Yeah, well, but we can see you. No, I hear you, but I can't see you on the TV screen, on the screen. Yeah, should do that. Yeah. Get out and get in. Yeah, do that. Ele vai entrar e sair.
Saiu aqui, daqui a pouco ele vai entrar.
Pois é, vai entrar agora. Foi?
Are we back?
Yeah, sure.
Okay. I'm not sure where you lost me or I lost you.
You were talking about the three, cases that you were going to, discuss, and that's it. You finish talking
All
about
right.
the United Nations, and then you disappear.
Okay.
You didn't explain anything else.
Did I say anything about the flourishing of international law in the post-World War II period?
No.
Okay, so let me then go to that. So I wanted to say a few things about the International Court of Justice and its role in the international law and international legal system. So I suppose most of you are not international law experts. So international law has had a particular prominence in the post-World War II period. And of course, that was in reaction to the terrible events in that time period, ranging, I mean, that included the Nazi Holocaust, but also elsewhere led to the loss of upwards of 50 million lives. So international law and its main associated institution, the United Nations, including the International Criminal Court as its top judicial organ, were founded in 1945 and had as their chief mission ending the scourge of war. Since that time, we've also seen the flourishing of human rights law expressed through a variety of treaties like the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights. We had the elaboration of the rules of international humanitarian law, which governs the conduct of militaries during war. We saw that in the Geneva Conventions of 1949 and their additional protocols in 1977. We saw treaties to limit the spread or uses of nuclear, chemical, and other inhumane weapons of war, landmines, cluster bombs, etc. We saw the codification of the crime of genocide in 1948. And there were more of these developments. The last one of which I'll mention was the founding of the International Criminal Court in 2002. I will mention it again briefly in a moment. Now, the International Court of Justice exercises two kinds of jurisdiction. The first is what's called contentious jurisdiction, which involves disputes between states that are among the 193 members of the United Nations. The second kind of jurisdiction is advisory opinion jurisdiction, where an organ of the United States, such as the General Assembly, seeks the guidance of the court as to a matter under that organ's institutional mission. Under the court's rules, rulings in contentious judgments in contentious cases are binding upon the parties. They must comply with the ruling of the court, while advisory opinions are nominally, at least, non-binding. Now, this distinction between contentious and advisory opinion jurisdiction has bearing on the Palestine cases because the two genocide cases are contentious with rulings that should be binding when they ultimately come down. While the third case, the one that was just decided in July, was an advisory opinion and therefore is nominally non-binding. Although what this means, the non-binding aspect, is something that we might need to unpack possibly in discussion. Now, please take note of what is not included in the International Court of Justice, which I'll refer to as the ICJ. Take note of what is not included in the ICJ's jurisdiction, namely prosecutions of individual defendants for war crimes and crimes against humanity. Historically, that role has been played by special tribunals, such as the Nuremberg courts or the International Tribunal, the International Criminal Tribunal for Rwanda, or the International Criminal Tribunal for the former Yugoslavia. But in the last 20 plus years, we've also seen the emergence of the International Criminal Court, which I'll refer to as the ICC. ICJ is the International is the International Court of Justice. ICC is the International Criminal Court. Now, although the ICC also sits in The Hague, it is totally independent of the ICJ and of the UN system. It was formed by a treaty agreement called the Rome Statute that entered into force in 2002. And the statute, in addition to defining the structure of the court and its associated arms, also spelled out the crimes it could prosecute and by what procedures. Its jurisdiction is limited to the territories and/or nationals of its 109 signatory states. And it is only supposed to step in when the national courts of its member states fail to effectively prosecute violators. Now, you may be aware that there are Palestine-related actions in the ICC as well. Investigations by the ICC prosecutor into possible war crimes and crimes against humanity in the territory of the state of Palestine have been pending for years. And in April of this year, the ICC prosecutor announced that he was applying to the court for arrest warrants for 2 Israeli leaders, Prime Minister Benjamin Netanyahu and Defense Minister Yoav Gallant, along with 3 Palestinian leaders of Hamas, 2 of whom have since been assassinated by Israel. The court, the ICC court, that is, has not yet responded to this request, but there is at least this alternative forum in which accountability for possible war crimes and crimes against humanity in the region can be sought. And it is not irrelevant to my topic today, but there is plenty to discuss with regard to the 3 cases in the ICJ alone. And unless you ask me during the question and discussion period, I will now return to focus on the ICJ cases. Now, in a moment here, I want to draw a contrast between international law on the one hand and the rules-based international order on the other. And I will be criticizing, in particular, one of them, the rules-based international order. As I do so, however, I want to be clear that we must not romanticize nor exonerate international law nor international institutions. There is much to criticize in how systems of international law have functioned or not well before these 3 cases arose, the 3 Palestine-related cases. And the poor performance of international law and institutions, particularly in limiting war, is by no means limited to Palestine. Just this past week, Mongolia, a member state of the ICC, refused to arrest Russian Premier Vladimir Putin on a warrant issued based on Russia's actions in the Ukraine. And there are many such examples going back in time of powerful nations essentially ignoring the rulings of international legal institutions. But whatever the failings of international law and institutions, they are far less problematic than their alternative in the rules-based international order. Now, as I said, international law refers to the rules that have arisen over the last 500 years or so that govern relations between nations and increasingly other subjects of international law. The rules-based international order has a less widely accepted definition. But what I mean by it is a set of principles that US officials, United States officials, have been invoking with increasing frequency ever since the 1991 demise of the Soviet Union. If the term rules-based order or rules-based international order seem unfamiliar to you, listen for it, because you will soon hear it from President Biden, from our Secretary of State, Antony Blinken, or our White House spokespeople. They use this term all the time. The principles of the rules-based international order include democracy, the rule of law, free trade and markets, collective security, multilateralism, and protection of individual rights. And this rules-based order is often presented as one pole in a grand global struggle between democracy, led by the United States on the one hand, and autocracy, authoritarian government, on the other. And while the rules-based order principles in the abstract mostly sound like good things, the problem with them is that they are, unlike international law, or at least as compared to international law, ill-defined and vague, and therefore flexible to interpretation. Nor is it clear who exactly has the right to define the rules of this rules-based order, nor how they are generated. As a matter of practice, it turns out that it is the US that invokes these rules, usually against our chief geostrategic rivals, Russia and China. So in a June 2022 New York Times op-ed editorial, President Biden said that Russia's invasion of Ukraine, and I'm now quoting, could mark the end of the rules-based international order and open the door to aggression elsewhere with catastrophic consequences the world over. Unquote. Let's be clear. President Biden could have invoked international law here rather than the rules-based order, because Russia's invasion of the sovereign state of Ukraine certainly violates international law and the Charter of the United Nations, which only permits war in self-defense from imminent attack or when explicitly authorized by the United Nations Security Council. He did not, that is, President Biden didn't refer to international law. Another context in which the US invokes the rules-based order is in relation to China's actions in the South China Sea. Now, as it happens, the United States is not a signatory to the Law of the Sea Convention, as we are not to many conventions that other countries have agreed to respect. So we are in no position, I'm speaking now as a citizen and resident of the United States, we are in no position to rely on international law vis-a-vis China because we do not abide by it. We don't agree to be bound by it ourselves. I should note that in a recent survey rating the compliance of 74 nations with the United Nations Charter going back to 1945, the United States ranked last and Israel second to the last. So I think you're probably starting to see why I say that there is a contrast, if not a contest, between international law and the rules-based order. And hopefully you're beginning to see what function the rules-based order plays in American diplomacy. I mean the United States, in US diplomacy. And that is as a way to legitimate what our leadership sees as being in our geostrategic interest by wrapping it in a facade of law that is, in fact, totally subject to unilateral US definition. But why do I say that these three Palestine-related cases present a turning point in that contest, as I believe they do? Let's take a quick look at each of these three cases that have been before the ICJ over the last year. The first of these, South Africa versus Israel, was filed in December of 2023 by South Africa against Israel, claiming that in its onslaught against the Gaza Strip, Israel was violating its obligations under the UN Genocide Convention. The convention binds all of its 153 signatories not just to refrain from genocide, but to act affirmatively to prevent it when there is notice that genocide may be occurring, and also not to join in or be complicit in genocide. And it is according to that obligation to act affirmatively that South Africa took up the case. And it is also, by the way, the basis for Nicaragua's, one of the other three cases. It is also the basis for Nicaragua's case against Germany. South Africa requested that the court indicate provisional measures. In other words, to take emergency action to preserve Palestinian rights during the pendency of the case, which is going to take years to resolve. Hearings in the case were held in January, in which both sides presented evidence and argument on the request for provisional measures. The result, it's, I think, fair to say, was a significant vindication of South Africa. The court, importantly, found plausible evidence that genocide was occurring in the Gaza Strip and ordered that Israel do everything in its power to prevent genocidal acts, to facilitate the entry of aid and its distribution in Gaza, to punish incitement, to bar and punish incitement to genocide, and to report back on its efforts within a month. That month passed, and Israel submitted a report on its compliance privately. In other words, it was not shared with the public. Meanwhile, as you likely are aware, the situation on the ground continued to deteriorate. Okay, now this prompted the deterioration of the conditions on the ground, prompted South Africa to go back not once, but twice to seek additional provisional measures. In March, the court agreed and ordered that Israel that Israel cooperate in the provision of humanitarian aid. And then, as Israel was threatening to invade Rafah, where more than 1 million Palestinian refugees from the northern part of the Gaza Strip had taken refuge, South Africa went back to the court seeking yet again more provisional measures. And this time in May, the court ordered that Israel halt its military operations against Rafah, an order which, again, as all of you know, Israel has simply ignored. Now the court has set October 28th of this year for the submission of South Africa's written memorial, and July 28, 2025 for Israel's response. So under court rules, South Africa can return to the court to seek additional provisional measures, as it already has now 3 times. But barring that, it seems unlikely that we will have a decision in the case before 2026. It's worth noting that since South Africa initiated the case, 13 other member states, mostly but not exclusively from the Global South, have joined or declared their intention to join the case against Israel. Many others, including Brazil, through both your president and foreign minister, have expressed support for the case, although without joining it formally. Meanwhile, Germany early on declared its intention to join the case on Israel's side, although it's not clear that it has actually followed through on that commitment. And the US, for its part, has assumed no formal role in the case, but has dismissed it summarily in public statements as unfounded in either law or fact. Now, a quick look at the second case, Nicaragua versus Germany. This was filed, as I said, March 1st of this year. This was more than a month after the ICJ had ordered provisional measures in the South Africa versus Israel case. And this was after Israel had submitted its report on compliance. Germany is charged in this case with violating its duties under the Genocide Convention and other provisions of international humanitarian law, such as the Geneva Conventions, by providing arms aid to Israel, by cutting off aid to the the United Nations Relief and Works Agency, which provides relief aid, healthcare, education, and the like to Palestinian refugees. And this was, Germany persisted, Nicaragua was charging, Germany was persisting in this despite being on notice from the ICJ's decision in the South Africa case that there was a plausible case for genocide. Some questions that we may want to come back to in discussion. I'm not going to say a whole lot more about this case. Why Nicaragua? Why is Nicaragua the plaintiff in this case? And why is Germany the nation that is being accused of complicity in the genocide? And I think just in the interest of time, I'm not going to say a whole lot further. I'll say a couple of things. So far, the court has made only one interim ruling in this case, declining Nicaragua's application for provisional measures that would have included ordering an immediate halt to Germany's arms shipments to Israel. Looking at the pleadings in this case, it is, in my view, this case is the weakest of the three in legal terms. More than anything else, it strikes me as an act of desperation by parts of the international community to do something, anything, to halt the continuing wholesale slaughter of Palestinians and the complete destruction of the conditions for life in the Gaza Strip. Finally, let me turn to the General Assembly's request for an advisory opinion on the legal consequences arising from Israel's more than 57-year occupation of the Palestinian territories. As I stated, an advisory opinion from the ICJ comes upon a request from a UN body which is asking the ICJ to render a legal judgment to guide the requesting body in its work under the UN Charter. Any member nation and even regional organizations can address the court. And in fact, in this case, an unprecedented 52 states and 3 regional organizations joined in the hearings that were held in February. Israel itself actually chose to abstain from the oral arguments. Although the United States did, this is the only one of the 3 cases in which the US actually had a formal and speaking role. Now, a couple of points about this case. On the one hand, it is narrow in that it only examines Israel's treatment of the Palestinians in the occupied territory. It does not touch on the status of 1.9 million Palestinians who are second-class citizens of Israel, nor on the rights of 4 to 5 million Palestinian external refugees to return to their homes and homeland. So it very much stays within the parameters of the international consensus in support of two states for two peoples. On the other hand, it was and is very open-ended as to the legal questions in regard to Israeli occupation. What I want to highlight here for a moment, though, given our concern with the contrast between international law and the rules-based international order, is the position that the US took in the hearings. Our State Department lawyer argued that the International Court of Justice shouldn't order a unilateral end to Israel's occupation because this would undermine the Land for Peace framework established by the United Nations Security Council in its resolutions 242 of 1967 and 338 of 1973. Now, this audience, you're probably not students of UN history in relation to this conflict, but essentially those were agreements, those were United Nations Security Council resolutions that were adopted in the aftermath of wars in 1967 and 1973 between Israel and the Arab states that have been understood to have set up a framework for the exchange of land, the land that Israel occupied in 1967, for peace with the surrounding Arab states. Now, the argument that our State Department lawyer made before the ICJ is that if the court ordered the return of the land, this would hand Palestinians the land without handing Israel peace, neglecting its security interests. Now, and this position has been reiterated by US officials in the aftermath of the court's ruling. So a few observations about that position, and which is sort of classic rules-based thinking and rhetoric. First of all, the supposedly foundational UN Security Council resolutions were adopted, as I said, after wars between Israel and the Arab states, and make absolutely no mention of the Palestinians nor of their national rights, referring only to a just resolution of the refugee issue without naming who those refugees are nor whether they have national rights. They staked out a legal position, a political, not legal position, and were arrived at by a political process, that is negotiations within the Security Council, in which Palestinians had no voice or part. Now, the United States has not seemed in any way offended by treaties between Israel and Egypt in 1979, Israel and Jordan in 1974, and more recently, the US has strongly pushed the Abraham Accords between Israel and now 4 Arab countries, all of which gave Israel peace with Arab states without giving Palestinians land. So just to underscore the flexibility and, I would say, hypocrisy of the US-defined rules-based order, the emolument or the inducement that the United States offered to Morocco to get it to recognize Israel and to conclude a normalization agreement with it, was the United States recognition of Morocco's sovereignty over the Western Sahara, which is also clearly in violation of the UN Charter. So why is the US okay with peace with no land, but no land without peace? note that Israel benefits in both cases from this hypocrisy. Now, you might ask yourself, wouldn't a court judgment that clarified the rights of the respective parties support a fair and just resolution in accord with international law? The answer, I believe, is yes. So U.S. opposition to an ICJ judgment makes sense only if the settlement it envisions were inconsistent with international law. And that would be true of an agreement in which Israel kept lands in the West Bank that it acquired in violation of the UN Charter's rule against the territorial acquisition by war. So it also seems evident that the US would prefer that Palestinians be forced to continue to negotiate while the occupation continues, or in other words, at the point of an Israeli gun. Even though it is this asymmetry of power that is at the root of the failure of the now 30-year-old Oslo Accords and the so-called peace process. Again, this is classic rules-based order thinking in which power, not justice as embodied in international law, is the ultimate arbiter. Now, I'm approaching the end here. I want to tell you a little bit how this case turned out and then reflect a little bit on what the three cases together suggest. On July 19th, the International Court of Justice issued its advisory opinion on the legal status of Israel's occupation, and it was a bombshell. It was a sweeping victory for the Palestinians on virtually every essential point of law. The International Court of Justice often votes on discrete legal principles. So a judgment isn't just on one issue, it might be on multiple issues. And in this case, there were votes on 9 distinct principles of law. And in each of them, the principle was supported by strong majorities. The weakest of them was a vote of 11-4. There were 15 judges on the court. Others were 13-2 or 14-1. So it was not a close case for most of the judges. The judges did not vote along country lines, as some might expect. The American and Australian judges, for example, voted down the line in support of the majority and, in support of positions that protected and defended and vindicated Palestinian rights. Among the major findings of the court is that Israel's 57+ year occupation of Palestinian territory, including East Jerusalem, the West Bank, and the Gaza Strip, is illegal in its entirety on 2 grounds. First of all, it amounts to de facto annexation, which violates the UN Charter's prohibition against the acquisition of territory by war. Second, in doing so, it denies the Palestinian people their right of national self-determination. Now, this is different from previous findings that discrete Israeli practices are illegal. What the court said was that the occupation in itself violates international law and accordingly must be brought to an end as soon as possible. Among other principles that were laid down in the decision, all Israeli settlements in the Palestinian territory are illegal and must be withdrawn along with the settlers who reside in them. Israel must allow displaced Palestinians to return to their homes and properties and receive compensation for their losses. Israel's treatment of Palestinians in the occupied territory violate international conventions against racial discrimination and apartheid. And finally, Israel does not have a right of self-defense in relation to the territory it has illegally occupied for 57 years. Instead, that right is held by the Palestinian residents of the territory. Now, in other words, a more complete victory for the Palestinians and those who supported them in the case could hardly be imagined. Now, I say this even while recognizing the limitations of the case from its outset. First, that it dealt only with Israel's treatment of the Palestinians under occupation, and more importantly, perhaps, that by its nature as an advisory opinion, it is non-binding. I don't think, by the way, and I can explain this point, but I don't believe this means that states are simply free to ignore the ruling. I don't think that's what non-binding means here, but we can discuss that later if you're interested. Okay, I'm almost done. Where do these three cases leave us? Well, I think it leaves us with they leave us with some very serious questions. Will it be, or will it be the primacy and universality of international law that prevails? Are international law and the architecture of the post-World War II international system up to the test? Can they effectively halt a genocide in action? This is, after all, widely recognized to be the worst possible crime that can be committed by a state. And Israel has just demonstrated its ability and willingness to exert the same levels of violence against residents of the West Bank as it has been exerting against Gaza for nearly a year. In other words, we're looking at the possibility of the expansion of the genocide out of the Gaza Strip and into other areas inhabited by Palestinians. Will we continue to tolerate a decades-long occupation that the entire world and now the International Criminal Court recognizes is not temporary and has evolved into a mechanism for racial oppression tantamount to an acute form of apartheid? Or will the international community yield to the flexible heads I win, tails you lose construct of the rules-based international order, where it is heads, the US and its small clutch of global partners win, or tails, where opponents of the US lose? Here's another very challenging and difficult question, I think, and that is, do symbolic spectacles that are not accompanied by concrete actions, including those at the International Criminal Court, function to appease protesters, both states and members of civil society, and siphon off energy from other actions that might ultimately have greater effect on the ground? In fact, I can name only two states, Colombia and Namibia, that have actually taken concrete actions that might impact the situation on the ground in Palestine. Namibia has recently held up an arms shipment to Israel passing through its port, and Colombia has suspended coal exports to Israel. Meanwhile, South Africa has maintained normal trade and diplomatic relations with Israel, despite its leadership in the ICJ genocide case. And Brazil has also maintained its fossil fuel shipments to Israel, despite the government's criticisms of Israel's Gaza genocide. In 2022, Brazil provided 28.9% of Israel's crude oil imports and has continued its shipments in December of 2023 and February 2024 as the situation in the Gaza Strip deteriorated. So you have to wonder, do the rhetoric and symbolic gestures actually challenge the status quo of violence and oppression? Or do they in fact, and in effect, if not intention, support the status quo of violence and oppression? International law is legitimate insofar as it is fairly and universally applied. When it is applied selectively, unfairly, and cynically, it becomes nothing more than an elevated form of propaganda. That is the struggle currently playing out in the hallowed halls of the Palace of Justice in The Hague. The acuity of the crisis is especially heightened by the recency of the comparison of the US and Western European responses to Ukraine on the one hand and Gaza on the other. 2 years ago, you can find this online, you'll find US Secretary of State Antony Blinken decrying Russian bombings of Ukrainian hospitals, and properly so. Today, he excuses, obfuscates, and deflects when Israel destroys or disables nearly every hospital in Gaza and kills or abducts and tortures their staff. I will not predict the outcome of this struggle. What I can say is that the credibility of the post-World War II system is being stretched to the limits. And this is at a moment when we as a species face existential danger in the form of climate change and are most in need of international cooperation and peaceful means of resolving conflict. And on that somber note, I will end and look forward to your questions. Thank you.
Thank you very much, George. Well, now we'll listen to the Paula's comments, please.
Yes.
Hello, Professor George. Thank you.
Hello,
once
Paula.
more. Hello. Nice to see you again.
Nice to see you. Good
Wonderful
see
to
you.
have you again talking to us. You're such a
Thank you.
long-term partner for us here at the INEAC network and at our events at University VEIGA de Almeida. Such a generous contributor. I am not staying at home. I'm staying at my mother's house, so I'm far from my things, and I couldn't come wearing blues band t-shirt, so I could honor your presence not only as a scholar, but also as a great bluesman that I came to learn that you are. So yeah, to that, I just want to register my happiness to have you here. And also as a warning, I learned that not to reproduce a practice that is rather common among some of our legal scholars here in Brazil, who often speak about matters in which they are not necessarily well-versed in. And with that, I just want to say that that's not a subject I know much more about than anyone else who has been affected by this conflict and the horrible things that we see and learn about it throughout decades of horrors. So what I'm going to try to do is to present you with questions so I can try to challenge my own prejudices and refine my views about this conflict in the Middle East. As I understood it, you rested your reflection on the characterization of a problem, the slow pace or silence of international jurisdiction to provide its original raison d'être of ending war, and a hypothesis of causality for this related to the rules-based international order that, although theoretically full of good principles, democratic principles, due to characteristics such as indefinition and being subject to interpretation, results in practices with less than democratic impacts. This seems very interesting to me because as a Brazilian researcher of law, I am familiar with the impacts of indefinition and the very free use of interpretation for the uses of the law. And here it seems to have to do with a very hierarchical society and an inquisitorial society that results in the use of the law that is affirmed to be democratic in inspiration, being used quite arbitrarily in practices that are of with autocratic affinities. Of course, that's a completely different scenario. What I like to hear from you, however, is about the role of, you mentioned briefly, of the Democratic Republic of the United States in practices that end up having, say, autocratic or in any way less than democratic results in this matter, in this international matter. In one line, a comment on the relationship between law and politics. Law, in that sense, as an ideological mirage and imperialistic policies. What you called a hypocrisy seems sometimes to be a regular use of law as a discourse capable to produce injustice with political stability, as it produces the appearance of rule of law regularity. That leads to my next comment or question. Please feel free to say whatever you want on how you were affected by this. Internally, is that necessary? I mean, internally in the United States, is that necessary for public opinion? All that seems very technical to me for the American people to read about and take a position, form public opinion. Do the American people need this kind of legal ideological maneuver in order to not take the streets, for instance, even more away from university campuses, for example, as we've been seeing in many universities in the States, for that to spread out is what I mean, and rise against the United States government support to those responsible to Israel. Internationally, I believe we are witnessing one of the most shameful episodes of international neglect or silence in history. So what is an object of perplexity to me is like, why bother, since it seems explicit to me is what I mean. So why bother that whole maneuver? Is that necessary to legitimize it with an ideology? Because it produces an effective appearance of legality. As you pointed out about the continuance of economical relations with Israel, as you pointed out the example of Brazil, despite of a rhetoric of criticism, for example, of our president here, that's what it seems to me that it's necessary. It's a necessary ambivalence, right? So open conflict is bad for business. So it's necessary to produce conditions of keeping the conflict as much as it is as possible, producing the simultaneous occurrence of an injustice and political stability. I would just like to hear what you think about those things. Thank you so much again for coming to talk to us.
Hi, George.
Yeah. Did you want to say something, Roberto? Or shall I respond to Paula?
Well, I was talking these days with Paulo Gabriel, and we are discussing this kind of one of the subjects we talk about was this kind of a Palestinian situation, and I was asking him, how come this is happening? It's kind of this demonstration of the Zionist power in the world, of at least the Western world, is so incredible. I mean, even in the Brazilian Anthropological Association and and the Mercosul, you know,
Yeah.
whatever,
Yeah.
forgot the name.
Yeah.
They hesitate, you know, in pass a motion, you know, condemning this kind of situation, which is very, you know, unbelievable, you know, that we Brazilians, you know, that we know what is the American power, I mean, the American imperialism, and the Russian imperialism and whatever. It's not only American imperialism, but in this subject in particular, what is at stake is the American imperialism. And not only American imperialism, my Zionist imperialism, you know. And well, unhappily, he didn't have a good answer for that, because he was also appalled, you know, with this demonstration of, because it's so unjust and so obvious, the genocide and the situation that, you know, and it's going on and on and on and on and on, and nothing happens, you know. So it's very intriguing, you know. On the one hand, but of course there are a lot of geopolitical, you know, situations and reasons. But what I say is that sometimes, like Iraq, like now, you know, Palestine, and, you know, sometimes this kind of the covert of law, and the covert of a just war, like says Walzer, you know, the just war, you know, it disappears, you know. It disappears because there is no just law, you know, in about 40,000 people dead. Yeah, you know, it's you know, clear, you know, with the TV and you know, internet and whatever, you know, and everybody knows what's happening. There are no secrets anymore, you know, about this. I mean, of course, there are a lot of secrets, but not of the situation itself. It's not being hidden, you know, by any means. So I know that probably you cannot answer this properly, but you can comment on that at least. You know, that was what I would like to talk to you. You know, in this situation specifically. Thanks.
Thank you.
Waiting for you.
Let me. I think the questions that Paula raised, and thank you very much, Paula, for your thoughtful intervention, and the question that you raised, Roberto, here at the end are quite consistent. So let me. I will sort of go back and try to go through them from beginning to end, but I think they, you know, my response will be kind of to all of the questions at the same time as well. So I would not characterize the rules-based order as a cause of this of this current situation in which we find ourselves. Rather, I would describe it as a form of rhetoric and discourse that is used to justify, you know, the U.S. pursuit of what it perceives to be its geostrategic interests. And the advantage that the rules-based order has over international law as such is that we are the ones who define it. It sounds like law. It sounds, you know, all of the principles themselves in the abstract all sound fairly appealing. I mean, we might have different views on free markets and that sort of thing, but, you know, protection of individual rights, how can you argue with, you know, those kinds of principles? And so, you know, it puts us in the position of being able to define principles in a way that mask, obscure, and enable our pursuit of our geostrategic interests, especially where they deviate from, you know, democratic principles. Now, this is not new. This is not new. I mean, since you know, the birth of American empire, which, you know, really started, I mean, it depends on whether you want to look only at the expansion outside of US borders. You could look at the westward expansion within what became the United States as part of this process. You could look at our conquest of Hawaii, and you know, many other places throughout the world. You could see all of this as you know, part of the expansion of U.S. imperialism, but especially, you know, after we replaced the, you know, Great Britain as the, you know, as the principal force in you know, in the Western world after World War II. We have always intervened in other countries' affairs. We have deposed democratic governments throughout the world, from Iran to Chile. We have supported military governments, and you know, we have assassinated, we have imprisoned, we have, you know, we have intervened in elections, in all over the globe. And that is why that study that I cited to you found that the United States, is the worst offender against the UN charters, you know, since its founding in 1945. Now, you know, is this who is the charade for? Who is the pretense of legality for, and is it necessary? I think that's a really good question. I don't think that our you know, that our ideological pretensions are convincing very much to the victims, to our victims around the world. You know, I mean, it hasn't persuaded anybody who has been on the receiving end of American power. You know, when your family in Yemen is obliterated by a US drone attack, you know, ordered by President Obama, it doesn't, you know, it doesn't give you a lot of comfort that President Obama set up a, you know, you know, a council to sort of deliberate over when and whether to issue these, you know, to authorize these drone strikes. But it is meaningful within the United States. It is meaningful, I think, in our alliances with other, you know, other Western countries. It is persuasive to you know, to the political elites, the political class, and it. I think that even though it doesn't necessarily garner a great deal of popular support, it garners enough support from the, you know, from the holders of power to keep the operation going. Now, I think this has become particularly clear over the last year here in the United States, where the public, including especially Democrats, who are, you know, who are the greatest concern for, you know, the sitting president Joe Biden, and now for Kamala Harris as his as his possible successor, it's mostly Democratic voters that they care about, or that they care about in the first place. Democratic voters have overwhelmingly, from very early on, supported a ceasefire in the Gaza Strip. They've supported an arms embargo against Israel. They have, they have taken, and they've been out in the streets by the thousands, by the hundreds of thousands. And the political class, if you listen to them, is, they are almost uniformly staunch in their, they call it, Israel's right to defend itself. I think the solidarity of the ruling class itself is actually quite important. There are cracks that are beginning to appear in it, but it's still, still strikingly solid. So it's not that the legalisms and the the rules-based order win over large segments of the public. It's that it maintains the solidarity of the ruling class. And that, of course, I think answers the question of why, why the Secretary of State and the President and the like, they bother to justify it. They spend the time and the energy to kind of defend their actions. I think part of what's going on here, and now I'm shifting slightly more to respond to your question, Roberto. I think part of what's going on here is that we have an international legal system that was consciously designed in the post-war period. The United Nations, with the Security Council and the permanent members of the Security Council, and their ability to veto the permanent members' ability to veto any resolution, we have a structure that was consciously designed to be victors' justice, right? I mean, what is the justification in 2024 for permanent membership for France or the UK on the Security Council, and not for India, not for Brazil, not for South Africa, not for any one of a number of other countries? We are dealing with a kind of a relic of the constellation of power at a particular point in time in the middle of the 20th century. What's happened in the meantime, however, is that law has actually moved. The structure for the enforcement of law has remained unchanged, but the law itself has progressed quite a bit. As more and more nations joined in the direct aftermath of World War II, what were there, 40 or so members of the United Nations? I don't remember the exact number, but it was relatively small. Most of the world was not represented there. And slowly, nations joined. We had the great movements of decolonization through the 50s, 60s, 70s. A lot of law was generated during that time that had to do with decolonization, that had to do with the definition of the crime of apartheid in 1973 in the UN Convention. So not just the victors began to have their say in the development of substantive international law. Now, this case that the ICJ just decided regarding Israel's occupation of the West Bank is the first time that an international court that I'm aware of has adjudicated the question of whether Israel or any other nation is committing the crime of apartheid. This is a novel legal development, and for its part, the United Nations and other Western nations, they have tended to deride these developments in substantive law. But and even while they maintain their grip on their control of the instruments of enforcement. So we have this growing disjuncture between substantive law that has been supported by vast swaths of humanity and the enforcement mechanism, which is still controlled by the few. And, as to why Mercosur and individual nations have been reluctant to comment, well, it's clear, I think, quite clear, that it's fear of United States wrath, which through its exercise of sanctions and its control over the international monetary system can inflict a great deal of pain on nations that step out of line. And of course, we in the United States are very, we have sanctions against so many countries now for their misbehavior, according to, their failure to live up to the rules of the rules-based order. And so nations and leaders, corporations and the like, they have to think twice about whether to cross the United States. Now, the other thing I think that's, as I mentioned, the growing disjuncture between substantive law and the views of many people throughout the world in support of those changes as against the continuing control of the levers of enforcement. I think the rise of social media is another fairly significant development here. And you have referred to the fact that, that the spectacle is unfolding before our eyes. And I'm not aware of, there have been many, many, many genocides through history. They've been awful and horrible and equally brutal, at least, 9 million people killed in the Belgium Congo by, under King Leopold, some say, so the brutality is not new, but our exposure to it almost in real time is fairly new. So because, social media is not yet strictly under the control of the government, people are seeing things that they have never seen before. And I think, again, that contributes to that, to that passion and that passionate engagement that we're seeing around the world, around Gaza, including in the United States. And I actually, notwithstanding the horrible and continuing reality of what's going on in Gaza, now being shifted perhaps to the West Bank, where, by the way, today I learned, just as we were getting ready to get on this morning, an American citizen was killed by the Israeli Defense Forces, or I don't call them the IDF, I call them the Israeli Occupation Forces. But they were, young American woman, Turkish American woman, was shot dead during a demonstration against home demolitions or home, seizures. I don't know the exact details. And we're going to see. I can tell you, because I've seen this before, that there's going to be no expression of concern about this young woman's life, the way we saw over the recent death of the Jewish American, Israeli American, who was abducted by Hamas and recently killed there. So you know, these contradictions are more and more evident, I think, to people, and they are asking questions about what's going on here in a way that they never have in the past. People are getting educated, people are gaining awareness, and as they do, their commitment to engage and to make change grows strong. So, despite the immense suffering, immense and continuing suffering, there are certain ways in which I am more hopeful for a better future than I ever have been in my lifetime. And as you know, I've been engaged in this issue since I was a kid. So I've seen quite a lot in my years, and I do think that there is reason for hope.
Thank you, George. I'm very glad that you are so optimistic, and I hope everybody will be contagiated by your optimism. Well, are there any questions? Alguém quer perguntar alguma coisa? Paula traduz aí para vocês. Quem não falar inglês, infelizmente. Nada? Pra cá, porque aí não pode. Não, ele leva lá. Fica quieto. Fica quieto. Vou botar uma bengala, pô. Então,
sorry, George. Roberto says to me to be quiet and wait in my chair, in my seat, just to wait. Okay, so.
Because you hurt.
I have a walking stick, unfortunately, so he said to me, be quiet. Okay, the mic comes to you. Okay, so when we think in this kind of this awful problem, this important international issue that we have regarding to Israel and Palestine, I think. I mean, I'm a little bit optimistic to find a way to solve this problem or to address some path to solve this problem. But I don't know. Just to think together. I'm sorry. It's my problem? No? Okay. But I don't know why this UN system is collapsing, and it's collapsing in this kind of problem. I mean, we have a lot of evidence that Israel disrespects international law, that the U.S. disrespects international law and the UN Charter and other documents or normative documents. But I don't know if we have another, or if it's not danger. I think it's danger if we disrespect or not invest in this kind of international protection. I mean, I don't know, they are so explicit today, and Kant said, in the past they use this kind of justification, the just war, or we are fighting against an important enemy, or things like that. But nowadays they are explicit in disrespect international law and the UN Charter. So, on the other hand, we have a problem, because if we invest in this kind of discourse or analyzing this practice, we don't have any other institution to protect or to establish some ethical boundaries in international law. So I think we have an impasse here. How to reflect about that? So I don't know. I don't have a specific questions, but just to, if you can comment something about it, if we go in this kind of path, maybe we help to collapse the UN system. Okay. So thank you so much.
Thank you, Rafael. So, I'm waiting just for a moment because I'm getting a lot of echo right now. I don't know if that can be changed. I'll go ahead. Without, as I said, either glorifying or reifying international law, I agree that we venture into very dangerous territory if we don't find a way to live peacefully and to resolve disputes peacefully, with law being one of the tools for accomplishing that. In the very early days of the U.S. invasion of Iraq in 2003, the Iraqis captured several American servicemen, soldiers, and they, were proud of their accomplishment, and they paraded these young men before television and broadcast it, to the world. Now, Donald Rumsfeld was our Secretary of Defense at the time, and he, went crazy screaming about how the display of prisoners of war was a violation of the Geneva Accords. Not the Geneva Accords, but rather the Geneva Convention of 1949. And he was right. He was correct. And to their credit, the Iraqis stopped this practice of displaying U.S. soldiers that they had captured on television. Now, this was in the context of a war that was itself the attack, U.S. attack on Iraq was totally illegal. But it underscored the ways in which international law protects even the powerful. And it was a very sort of poignant reminder of how quickly the tables can turn and cause one to seek the protection of international law. What is required for the consistent and universal application of international law is, I think, the ability to put oneself in the place of the other and to imagine what it would be like to be subject to the law that you are proposing to apply. So, for example, I suspect that President Obama, who is about as ethical a politician as you could imagine, winning our presidency, I don't think he ever really thought about the possibility that he might be subject to a drone strike by another country, or that our soldiers would be subject to a drone strike from another country. And that's what you kind of have to do. You have to think, okay, well, if I'm going to apply this to somebody, how would I like it if it's going to be applied to me? And if you don't find it acceptable being applied to you, then you probably shouldn't apply it against other people. Now, to do that requires humility. And that's something we don't have much of here in the United States. We think of ourselves as the exceptional nation, as the essential nation, as the good guys in this great global struggle between democracy and autocracy, and that I think is a great shortcoming. in our vision. But I do think that, you know, I don't know, as I said, what is going to become of these cases in the International Court of Justice, what their ramifications will be. I mean, if there is a finding that Israel has committed genocide, and I think that's a real strong possibility, that is, that the court will find that Israel has committed genocide against the Palestinians in the Gaza Strip. There's one could challenge that that prediction, but I think it's fair. You know, what will become of that judgment? I think, you know, the further we go, and as the dangers of climate change and the social disruption that climate change is going to bring, the refugee populations that will be fleeing areas that are either submerged, you know, island nations that will be submerged, or places where you can no longer grow crops or survive the heat, as all of those things drive, you know, refugees into places seeking safety. There's going to be a great deal of unrest, and we absolutely are in urgent need of tools to cope with these challenges. So, you know, without being a romanticist about international law, it seems to me that at least it is one of the resources that we need to build up. I'll just say one other thing, and this kind of also refers back to questions that Paula and Roberto raised that I think I didn't fully answer. One of the counter phenomena that we are seeing is the rise of naked racism and ethno-nationalism in many countries, you know, ranging from India to Hungary to Israel, the United States, and elsewhere, where, you know, populations are feeling threatened, feeling jeopardized, and are resorting to racist ideologies to kind of mobilize force to protect their perceived interests. And I think part of what we're seeing and you know, it's represented in our country, of course, by Donald Trump and, you know, many of his followers. I think we are seeing a return for some people to a kind of might makes right. You know, brute force there's nothing wrong with it when it's exercised in a way that is in defense of the nation, and so it's a very potent political force in today's world, I think, in many parts of the world. And so it's not like the positive trends are necessarily dominant. There are a lot of challenging forces in the political world that we'll have to contend with, that will see things completely differently, and that see the current direction of matters as perfectly okay or even desirable. So those are going to be our, those are going to be our challenges going ahead.
Thank you, George. Well, mais alguma coisa? Any more questions? Alguma questão mais? No? Okay. Well, then we are going to finish with this roundtable. It's not a round table now anymore. It was a conference, right? I'm a little tired, you know. Today's on the roll is a little bit difficult. Anyway, let's stop this, and thank you very much, George, for your generosity and availability of being here with us once more. Hope to see you next year in person, as well as your colleagues and eventually your friends. And we were going to fight for funds for
Wonderful.
financing this trip. I was talking with my friends, and we were very fond of the presentations, and we
Good.
think that we can have more. We can develop this kind of
Yeah.
relationship, academic relationship,
Wonderful.
in a very fruitful way for everybody. And
I
thank
hope
you
so.
very much for that again.
Absolutely. Absolutely.
Okay.
Thank
And
all
so
of you, Roberto and Paula, Rafael. Really appreciate it.
we'll talk a little bit later. We'll talk about how to publish this all these things. I don't know if you wrote your presentation, but if not, we'll as usual we'll take it from the records and send it
Okay.
to you for revision.
Great.
And so, my friends, it's over.
Thank you. Bye-bye.
E agora, para o outro lá com a mão assim, fazendo assim para mim. Então, assim, ele quer continuar, entendeu? Continua. Mas ele mesmo não segura a pemba e tal. Continua, Zé. Tá. Agora, então, para terminar, né, vamos fazer uma mesa de encerramento aqui. Eu vou chamar os nossos, né? O professor Rafael, coordenador